Good afternoon, everyone, and welcome to today's War Stories webinar featuring Morgan Chu. This webinar is sponsored by the Beverly Hills Bar Association's litigation section, chaired by Hillary Johns. Today's program is chaired by committee member and incoming litigation section chair, Rudy Lair. And I'm the moderator, if you will, Travis Anderson of Shepherd Mullen. The program materials have already been emailed to the attendees, and they'll also be posted in the chat box today. The MCLE certifications will be sent out within 24 to 48 hours following the program. Let's turn to the star of today's webinar, Morgan Chu. His accomplishments, accolades, and credentials are legion and could easily take up the entirety of this program. Despite choosing not to finish high school, Mr. Chu holds multiple degrees from UCLA, a bachelor's in political science, as well as both a master's and a PhD in urban educational policy planning. He then garnered a master's of studies in law from Yale Law School and a JD, magna cum laude, from Harvard Law School. All 5 of these degrees were achieved in the space of 5 years. Mr. Chu went on to serve as a law clerk for the Honorable Charles M. Merrill, U.S. Court of Appeals for the Ninth Circuit. After completing his clerkship in 1977, Mr. Chu entered private practice as an associate at the Los Angeles powerhouse law firm of Irell Manella, where he became partner 5 years later and where he remains to this day. On the firm management side, he served as the co-managing partner from 1997 to 2003, and has been a member of its governing board, the executive committee, since 1985. All of that alone would constitute a storied legal career, but it hardly scratches the surface for Mr. Chu's. His prominence as an intellectual property attorney, as well as a trial lawyer, has yielded extraordinary results for his clients. He was lead trial counsel in some of the world's largest and often precedent-setting verdicts, judgments, and settlements, resulting in actual payments totaling more than $9 billion with a B. He has been described in Chambers USA as, quote, beyond doubt, the most gifted trial lawyer in the USA, who, quote, delivers staggering results for his clients, end quote. Mr. Chu also achieved a unanimous ruling in his client's favor before the United States Supreme Court. In addition to devoting himself to his clients, Mr. Chu has also devoted himself to numerous philanthropic endeavors. For example, he handled a 6-year extensive pro bono death penalty case. He's also the longest serving board member of Public Counsel, the nation's largest pro bono law firm, and serves on the City of Hope Board of Directors and chair of the City of Hope National Medical Center Board. He was president and chair of the Harvard University Board of Overseers, a governing board of the university, and is a fellow of the American College of Trial Lawyers. In short, Mr. Chu has done it all and continues doing so to this day. We are delighted to have him here today to discuss some of his experiences which helped shape him as a trial lawyer and explore his approach and strategy to distilling complex points of law and fact into a message that a jury can not only comprehend, but grasp so intuitively that it compels them to award sums far beyond most mortals' comprehension, and most litigants' comprehension for that matter. If time permits, Mr. Chu will answer questions from the audience. Those questions can be inputted into the chat function of this program, and I'll be monitoring those and saving time at the end to address them as appropriate. But without further ado, Mr. Chu, welcome to the webinar.
Thank you very much, Travis. Thank you for the overly generous introduction, which was mostly accurate.
All right, well, let's dive right into some of your pre-law experiences, if you will. I understand you intentionally dropped out of high school and traveled for a year before talking your way into undergraduate at UCLA. Given where you are now and looking back on your career, Do you feel that year was well spent, or do you wish you'd stayed in school?
In that instance, and every other instance where I was making a decision at a fork in the road, looking back on it, I was always very happy. Of course, I don't know what would have happened if I had taken the road not taken, but I would say in high school, I was having a great time. Before I dropped out, I was involved in 3 sports. First time in my life, by the way, I wore football equipment. It was JV football. For the first time I wore a helmet and pads and so on, as opposed to playing touch football, as well as 2 other sports. I enjoyed that. I enjoyed friends in high school and many other activities. But I was a little bit bored with the academic side. And I think a way to capture it is a teacher I had who didn't seem to have a good sense of humor, because we had a final exam, and the final exam was true false, and students exchanged papers after the exam was over to grade them. And I could hear murmurs in the back of the room where people were saying, Morgan got a 0? He got a 0 on the true false exam? And teacher picked up the papers, saw that I had gotten a 0, and he was striding toward me with a face that was demonstrating his anger. So I thought by the time he got to me, we were not going to have a successful conversation. So I got up and left the classroom. And that's a way to capture a key reason why I decided to leave high school. But everything else I really enjoyed about high school. So I enjoyed traveling. I enjoyed coming back. I did not enjoy applying to UCLA because I got turned down. And then I applied again in a week and got turned down. I went there physically and applied a couple more times, and it kept turning me down until finally someone in the admissions office said, well, why don't you come back tomorrow? I'm not promising anything. So I was very, very lucky that I was admitted.
So let's talk a little bit more about your time at UCLA and the 3 degrees you obtained from there in short order. A lot of really good lawyers have told me over the years, take some time before you go to law school. Spend some time in the real world, quote unquote, it'll make you a better lawyer. I'm curious to know, did these postgraduate experiences, the master's and the PhD, did it impact your approach as a lawyer, litigator, and trial attorney?
Yes, or I might describe it as being closely related, but I didn't know it at the time. I didn't know that I would ever go to law school or that I had any interest in law. I didn't know lawyers. But after becoming a lawyer, I found that being curious, being willing to learn just about anything, including subjects that one knows nothing about, but to learn them in a top-down view to see the big picture, but also to learn the subjects and the details at a very discrete level. And it turns out that those things which I've always enjoyed learning new things, end up being, for a trial lawyer, very important. And it makes being a trial lawyer fun because I get to learn new things every week.
I understand you tried your first patent case, which also happened to be the first patent case for your firm, after only practicing for about 1 year. Am I correct on that?
Yes, you are.
And I'd like to understand, how did that come about? And what advice do you have for junior litigators who are looking to stand out in a good way to clients and earn their trust?
At the time, there were no general practice firms that did patent litigation. And we had a client, I had done some work with the client, including with the general counsel, that had a patent case. They were a defendant in a patent case, and their counsel was being disqualified. So the general counsel talked to the senior people, had Irell Manella And the general counsel said, well, I'd like Morgan to try this case. Of course, I'd never tried a case. I'd never seen a trial in real life. I'd never been a fifth chair in a real life trial. I had watched Perry Mason, which certainly made me an expert in trial practice. But the senior people at the firm said, no, we can't do it because neither Morgan nor anyone else in the firm knows anything about patent law. And neither Morgan nor anyone else knows anything about the particular technology. General counsel was insistent. He said he would hire some other outside counsel. He had a well-developed in-house department, and that he would also hire technical specialists that would help me learn the technology. Because the litigation had been underway, within 9 months, we came to trial, and I had a lot of people helping me. Certainly, I was learning patent law from the ground up, and I was learning about the technology from some really terrific people. But the night before opening statement, I realized they didn't know where I was supposed to stand and where I wasn't supposed to stand. And I heard rumors that in certain courtrooms, you better not do this, you better not do that. I wasn't even sure what the so-called well is, because I think of a well as something you put a bucket down, get water, or something that in olden times used to hold ink. So it was about 8 o'clock that evening. I started calling other people at the firm, senior litigators here, and asking them not only about where do I stand, but a few other pointers that I hadn't figured out to ask about earlier. But it made the experience challenging and fun.
And what was the result?
Well, we ended up winning. We were representing an accused infringer, and we won across the board at the trial level. Went up on appeal, and we won across the board. It also happened that there were some people from major companies who had decided along the way to sit in on pretrial proceedings and the trial. So I suppose it would have been awful if we had lost, but having won, I think, as I was told later, there was some chatter among people in the bar, and they came from different parts of the country. Hey, there's this young kid, and he won this case, and he's not so bad. So that led to the phone ringing once in a while.
So let's turn now to a case that we're going to focus on quite a bit in today's webinar, and that is the City of Hope versus Genentech case. My understanding is this was primarily a breach of contract case with a lot of patent overtones and infringement overtones. I understand it resulted in, at the time, what was called the largest jury verdict in California that was affirmed on appeal. Could you describe a little bit of the background and facts of the case to sort of set the table for the war stories you'll share?
I'd love to. Many of our diseases are because our bodies don't make certain proteins or hormones, or don't make them at the right time, or sometimes make too much of them. And as an example, a terrible disease, including up to today, has been diabetes. And over many years, scientists had learned that a cause of diabetes was the inability of the body to make the right amount of insulin at the correct time. But they didn't know how to have good treatments for it, because they didn't know how to make human insulin. And over a period of time, the scientists and doctors would go to the slaughterhouse, and they would take insulin from cows or pigs, refine it, and then inject it into people with diabetes. And for some patients it worked, and other patients it didn't work at all. And for a good number of them, it actually made it worse because it was a foreign substance, and people would have an allergic reaction to it, and they'd be worse off. And the way of treating diabetes was thought, gosh, if we could make human insulin, but people didn't know how to make it. So these brilliant scientists at City of Hope they decided they would find a way. And here's what they did. They found a way to create a sequence that was a perfect replica of human insulin, but they didn't know how to replicate it. So if you have one such cell, it doesn't help. You need millions and millions and millions of the cells. And then they found a way to take these poor, lovely bacteria who they knew were really good at growing and dividing, growing and dividing. And then they found a way to trick the bacteria to accept this human DNA for human insulin, where the bacteria would think that it's the bacteria's own DNA, because if it was a foreign object, the bacteria would reject it. So there were some tricks there. There was some brilliant scientific work there. And ultimately, after a lot of failures, they were successful. So the bacteria essentially became pharmaceutical factories to make perfect human insulin. And that was the first biotechnology product ever. And then over the years, this technology, originally developed by the scientists at City of Hope, with some funding from some venture capitalists who were thinking of starting a new company that originally didn't have a name, but eventually they called the name Genentech. And the two, City of Hope and Genentech, had a deal where Genentech said, well, we want ownership of patents. And the agreement was Genentech could own the patents. The only inventors were at City of Hope, but City of Hope would get 2% of the revenues from sales of products by Genentech or other companies that Genentech would license the patents to. So that was the basic deal. That was the basic contract.
And what caused the rift? What caused the dispute that ultimately led to the trial in the case?
Well, first of all, for many years, it was a marriage made in heaven. There was a lot of additional work that had to be done. And over time, patents were applied for. There were publications about the work. There was on the floors of Congress a statement by the president of the National Academy of Sciences, who said, in effect, this is one of the greatest scientific achievements of all time, because it gave scientists the ability to attack many, many, many different diseases. And people's imaginations just broaden the thinking about how to treat diseases. And then products were made and sold, and City of Hope was receiving royalties. The agreement was entered into in 1976, but by 1998, there were some people at City of Hope said, well, we're not sure we're receiving all of the royalties, although they were receiving very significant royalties, because they would see some news reports about certain products that seemed to be using the City of Hope technology. So that came to the forefront. That led to discussions, led to tolling agreements, 6 of them, tolling the running of the statute of limitations. And then eventually a lawsuit was filed. And then the normal discovery process, and then trial.
And were you involved throughout that entire process, the tolling agreements, the litigation, as well as the trial?
Yes. And we were also very much involved in discussions. City of Hope made very clear that they didn't want to sue. I'm not sure that that's, if you're sitting on the opposite side of the table with someone who might be an adversary, I'm not sure that should be the topic sentence. Under no circumstances do we want to sue you, but that was what City of Hope, that represents who they are as an institution, and they were communicating that, and they wanted to have some information shared by Genentech. They wanted to be assured that they were being paid all the royalties that they were owed. And Genentech provided some limited information. And then after suit was filed, we got into discovery. We learned how limited that information was.
And let's fast forward now to preparing for trial. Although perhaps you were preparing for trial in a sense from the inception of the litigation, what did you come to identify as City of Hope, your side's weakest parts of the case? And how did you account for those and address them as you shaped your litigation and trial strategy?
The delay of time was the weakest part of our case. And there were subsidiary issues due to the delay of time. There were a couple people who passed away. There was someone who was a key negotiator of the 1976 agreement for City of Hope, who by the time of trial was quite aged. Now, his mind worked perfectly well, but there's always some diminution in the ability of someone to articulate things or to understandably remember with any clarity what was said and not said. So what was the delay of time? The agreement was entered into in 1976. Products were being made by Genentech and other companies by 1982 and being sold. This is after FDA approval. And then it's 1998 when the pre-suit discussions begin. So that passage of time might suggest to a judge or finders of fact, even if the statute of limitations had not run, that the plaintiff had just waited too long. And that problem was compounded by the fact of there were faded memories. Perhaps not all documents were preserved. I'm not suggesting that there were documents purposely destroyed by anyone, but neither City of Hope nor Genentech was necessarily preserving documents over several decades.
And so how did you account for that issue, particularly on your side, where memories had faded and there's an optics that, well, City of Hope must not have cared too much about this, given how long they've waited. How did you grapple with that in the context of the jury trial?
Basically, we were able to show that the information that would have put us on notice of a claim was being hidden from us. And it was not just a matter of omission, but as we learned in discovery, there were active efforts to hide the information from us.
And were those same actors who engaged in the hiding of that information on the Genentech side, were they present for trial, or had they were they no longer around in one form or another?
Yes, nearly all. There's just one exception who was a young venture capitalist at a firm called Kleiner Perkins, a well-known venture capitalist firm at the time and now, who had the idea of, hey, there's something called biotechnology. You've been reading about it. He's not a scientist, but being a good venture capitalist, he said, well, maybe someone's going to make money in this new area. And if there's a payday, I want to be there. So you might say that's a very positive trait about venture capitalists. They're trying to think about ways to turn things into money. And his efforts actually led to the founding of Genentech. He had passed away. He had, I think it had a tumor, a brain tumor, and it passed away at a young age. But most, if not all, of the other principal actors on the Genentech side were still alive and well.
For every trial, every anticipated trial, a litigator needs a theme and a good one, and generally a succinct one. Did you develop a theme early on in this case? And I'm curious to know whether you carried that theme all the way through to the conclusion of trial, or if it materially evolved over the course of the litigation.
If I would describe the core theme from the very beginning, even before filing suit, and I shorten it and state it in colloquial terms, I would say, they're cheating us. Of course, at the beginning, we said, we're not sure whether they are or not cheating us. But by the time we filed suit and had discovery, we were convinced that they were cheating us. Now, of course, in a courtroom, we're a bit more polite and understated than that. But sometimes if you just array the facts for the trier of fact and for the judge, then it becomes clear what's going on.
So in one sense, this is a breach of contract case and a failure to pay when money's owed. But in the background are relatively complex issues of intellectual property law, innovation, assignments of rights and licensing issues. I suppose kind of within that context, in the voir dire process, what kind of jurors were you looking for, and what kind of questions did you ask to sift through and find the right ones in your view, or the most optimal?
The way I would describe it for this particular case and every other case is, first, we're looking to decide who we want to deselect from the jury pool, who we want to use a preemptory challenge on. And so who are the jurors who might be very negative for our side? The flip side of that, of course, is say we want fair and impartial jurors. Obviously, if there was a way to select a juror who would be heavily in our favor, we'd want that. We certainly did a fair amount of jury testing. But one thing that we learned and was not self-evident to City of Hope and to me and other counsel on our side was the fact that we thought everyone should love City of Hope. It's a nonprofit. They have a wonderful history. They, for the first several decades of their history, never charged a patient a penny. And for several decades, didn't even accept insurance money. They actually lived by contributions and paid for all the bills and salaries and everything else in that way. It's an ideal nonprofit in a courtroom, we thought. Of course, part of what City of Hope did then and today is some groundbreaking research, as well as having a clinic, a hospital that provided services. One of its great specialties today is treating cancers of many, many kinds. But what we learned is that some people just hate hospitals. Now, my having said that, if I could see everyone who's listening in, would see a lot of nodding heads, because we've all been for ourselves or for a loved one or friend to an emergency room or at a hospital, or to visit a patient in a hospital, and they can be dreadful places. They're the opposite of being cheerful generally. People are harried. Sometimes people get very sick, and sometimes even sicker with diseases they didn't have when they came in. So there's some people who just hate hospitals. When we learned that, we became very sensitive to trying to learn about that. Of course, a prospective juror isn't going to say, well, I can't be fair because I just hate hospitals. But that's an example of a factor that we learn to give weight to in deselecting jurors.
I understand that Genentech had an excellent fact witness from your perspective. Tell us a little bit about that witness, and then how you approached him at cross-examination at trial.
His first name was Tom, is Tom. He's brilliant. He's great at strategy. He quite naturally is 2 chess moves ahead of everyone else in the room. He's very articulate. He understands the science, and heaven forbid I've made him better than Batman, Robin, and Superman combined. But in addition, he has a law degree and this bellowing baritone voice. I mean, he could be the announcer for CNN. So he was an ideal witness for them. We actually had 2 trials. We had the first trial in 2001. Mid-trial was September 11th. That day we didn't have trial. The next day or two, we didn't have trial because there was a member of the jury that had law enforcement responsibilities in Los Angeles and cities across the nation. Anyone with any law enforcement authority or responsibilities were on alert. That first trial ended in a hung jury. And part of what I was saying about jurors and how they viewed hospitals, we didn't know this at the time of a particular juror who became the foreperson, but we were permitted to interview jurors later. We learned it later that this particular juror really hated hospitals. He didn't quite answer the questions correctly. And he told us later that his father was killed by or murdered by a hospital. He was intent on suing the hospital back in Illinois, I think, and his brother stopped him from doing it. So he had a very deep-seated hatred. We, at that trial, Tom did an excellent job for Genentech, and they had some other excellent witnesses. Because it was a hung jury, it was 7-5 against us. I considered it to be a loss. We're representing a plaintiff. You got to get to the finish line. If you don't get to the finish line for whatever reason, including having a mistrial because of a hung jury, then I counted it as a loss. So after the jury rendered its verdict, it went back to the office with my colleagues, and we sat down and said, let's just dismantle our entire case. We thought we did a great job. We thought that there was not some glaring defect or that some witness of ours went off the rails. And then we had a watchword that we had to be not risk adverse, but risk preferring, willing to take chances, because we had 7 out of 12 jurors against us. And we needed to win. In California State Court, you need 9 out of 12 to obtain a verdict. And with the client's permission, we kept that in mind for every piece of evidence. What do we do if we're not risk adverse or we are preferring risk, not for its own sake? In other words, we're not going to grind out the yardage in a football game and get 3 yards on each play. But we had to throw some long passes and do other things and have some razzle dazzle. So one of the things we decided to do was to call Tom as an adverse witness. He was their best witness. But thinking about it, we thought, balancing all the risks, we might do better calling him as an adverse witness. And that's what we did.
And so in calling him as an adverse witness, why did you decide to do that? How did that change the overall structure of your presentation? And I guess relatedly, how did you see it affect the other side, given that you'd seen them try the case once before?
They were very surprised that we call him as an adverse witness, because you usually call people as adverse witnesses if you think they're bad witnesses, weak witnesses, witnesses where you would get great admissions. We thought that rather than have the jury hear our side of the case, and of course they'd be waiting to hear the other side of the case, we through him allow some presentation of the other side of the case before we rested, but that we could at least frame it by asking him leading questions in our case. Of course, it would open the door for them, the other side, to ask a lot of open-ended, non-leading questions to tell their side of the story, but they were going to get to that anyway. So as it turned out, after we called him as an adverse witness, he knows how to answer leading questions, but it became clearer after a couple hours that he wanted to tell a story that was different from the story he told at the first trial. And then a little pointer, there are different ways a trial lawyer kind of puts that off and says, oh, don't worry, Mr. So-and-so, we'll get to your side of the story. And lawyers always do that, whether they're going to ask questions for that witness's side of the story or not. And everyone forgets what the witness was intending to say. But he kept doing it. And then it became clearer the picture he wanted to paint to us. And then I finally started saying, I'm going to ask you an open-ended question later. And you get to tell your entire side of the story. His cross-examination was many, many hours, stretched a better part of 2 days. And then I finally said, oh, yeah, Mr. So-and-so, you can now tell your side of the story. But by then I had a very good idea of what he was going to say, because he would always try to add something to each of the individual questions I was asking on cross-examination. So he told his side of the story. I just listened and took notes. And it turned out that he completely changed his story. And in the end, I think that dramatically helped us, because the first trial, we did not have impeachment material from his deposition, where he was testifying in a matter at trial, contrary to his deposition. But now he was testifying at trial number 2 in a way that was contrary to his deposition and contrary to his testimony at the first trial. A simple way to think about it is there was a key meeting from his point of view that was many years before the lawsuit was brought, where he supposedly told some senior people at City of Hope how they were reading the agreement and why they were paying certain royalties and not paying other royalties. So it went to the heart of the case.
Let's also talk about expert witnesses, and it doesn't have to be the City of Hope case necessarily. Do you recall any great expert witnesses you've had to deal with on the other side? And if so, tell us a little bit about the scenario and how you handled that expert witness.
Boy, I've had a lot of good, excellent expert witnesses on the other side, but let me give you an example of one. And we usually prepare many notebooks, and I remember this witness, and I had about 4 3-inch thick notebooks of materials. Not that I would use all of them, but I could use a subset depending on how things went. And he was so good. He had the jury eating out of his hand. And in fact, he was eating out of my hand. He was persuasive. He looked good in the sense that he didn't have some expensive looking suit. I remember he was a little ruffled in terms of clothing, and he had patches on his elbows. Kind of a guy that you'd say, that was my English professor in college, and I really loved him. And I thought, gosh, and I'm reading some notes from my colleagues saying, don't cross-examine him. So I decided to put away all the notebooks. And I said, Dr. So-and-so, I noticed you were here earlier today, but you weren't here in the earlier days of the trial. He said, yes, that's right. I went through some of the earlier days in detail. And then I asked, well, you would agree with me that the ladies and gentlemen of the jury are in a better position to assess the credibility of George Washington, who testified earlier. It doesn't matter what he says. He can't say, no, I'm better to assess their credibility when I didn't see them at trial. So I went through George Washington, John Adams, Thomas Jefferson, a whole host of the other witnesses, the more important witnesses. And then I said, thank you very much. And I sat down. So the whole idea was, I didn't have really substantive things to cross-examine him on where I thought that we would score a point or two. But the goal was to empower jurors who might be inclined toward our side of the case to give them an argument in the jury room so they could tell their fellow jurors, we're told by the jury instructions, we're the arbiters of credibility. That's our job. And even though Dr. Muckety Muck told a good story, he didn't see any of the witnesses, and we can assess their credibility.
I love that. Essentially reminding the jurors they are the ultimate experts on the fundamental issue of credibility, and no one can supplant that. Let's return now to the City of Hope. I'd be remiss if we didn't get to some of the slides that you've brought today, virtually speaking, that I think are from the closing argument you gave in the City of Hope case. And maybe talk us through a few things. One, what you're trying to convey to the jury as you step through these slides, and also more generally, what your approach is to visuals and demonstratives when addressing a jury.
So just basic principles. As everyone in my firm knows, I have, it's a made up name. I call it the Billboard Rule. The concept is simple, but most presenters, not just lawyers, but presenters of any kind, violate it. And the Billboard Rule comes from this: if you're Beverly Hills in the business district doesn't have that many billboards. They're very touchy about it. But if you go farther west and you go down Santa Monica Boulevard or other places, you see tons of billboards. And the idea of a billboard is you're driving by and you get to glance at it for 1.5 seconds. And if it's a good billboard, you know what it's about. Sometimes it has 0 words. It doesn't have 25 words on it. And it usually has some graphics. And there's one concept that you're getting. So we want generally the slides to meet the Billboard Rule. So this is a title slide. And I'm going to click through some of these pretty quickly. This was just a slide showing the key facts. The contract had a lot of other provisions that were discussed, but this was the key parts of the contract. We wanted to say that the technology developed at City of Hope was so good that it resulted in 127 patents worldwide. And again, it's a billboard. And I wouldn't have had to say anything as a voiceover for people to get that. Another issue we wanted to have the jurors understand is what is a, quote, patent license, end quote, because the phrase patent license would not mean anything to most people. But a license, of course, is permission, and a patent license is permission from the patent owner to use the patented technology. So here's some simple slides to show that. There's a driver's license with some handsome devil there. And this is permission from the state of California to drive. There's beer and wine licenses, and then a patent license. So it's just permission. That's the concept. And then we had a series of slides where Genentech, the defendant, was saying, oh, it only had nominal licenses with others, but behind the curtain, we showed that there was evidence, agreements, this sample of those agreements, how much was received as of 1988, and then how much in sales there were by those companies. It's all meeting of the Billboard Rule. This is that key meeting I mentioned earlier today, where Tom Kiley is his name, changed his opinion. This is some details about it. First trial and a deposition, he said nothing happened at the meeting. Second trial, he suddenly had a lot of details. So we later said it seemed as if he had a recovered memory. And here's a deposition clip we played during trial as well as during closing. He's testified on cross details that he remembers about the meeting, and we're playing a clip from his deposition pre-trial.
Do you recall what was said in your conversation with Ed Irons?
I think we were just killing time.
There was no substantive discussion of parties' legal rights and positions, was there?
No. If there was, I don't remember it.
Are you aware of any
Sound okay?
conversations between representatives of Genentech and representatives of City of Hope regarding the interpretation of the 1976 agreement?
No.
Do you recall any information that you imparted to Mr. Irons during this meeting you had with him?
No.
And just to be clear, can you remember any information you imparted to him?
I don't remember imparting any information of significance to him. In fact, I guess I would say I remember not imparting any information of significance to him.
Did you ever have occasion to discuss the interpretation of the 1976 agreement with Mr. Irons?
I don't recall specifically doing so.
Do you have any recollection at all of having done that?
No.
Or with anyone else acting on behalf of City of Hope?
Not any conversations between myself and people at City of Hope.
If it's possible to have deposition testimony greater than 180 degrees, meaning in the opposite direction, you can see when he's testifying at the second trial about details of information, key information, material information, and our use of this clip to cross-examine him, hopefully was quite effective. Now, let me sort of fast forward. This is an example of a flip chart. It's just blank pieces of paper, and I had a magic marker when I was cross-examining him after he got, during cross, the ability to change his story. And then I said, well, how come you have this recovered memory? And I was writing down reasons, and then we took a photograph of it. We used it in closing argument with some explanation. And these were the different reasons he tried to give, and we explained to the jury why it didn't make sense. So let me sort of fast forward here. This was the funny part when I was asking the witness about his recovered memory. I said, well, did you have an automobile accident? Did you get hit on the head? And then at one point, I guess I was having too much fun. I said, did you take any herbs or pills or Chinese medicines or anything like that? And the judge leans over from the bench, and this is the judge's question: ginkgo biloba? Of course, the jury had a good laugh. We laughed some, but respectful to the witness, it was quite memorable. So we reproduced this for closing. So fast forwarding a little bit more. Now, this is, we call it the Hollywood squares. There are a couple other shorthand ways that we describe this. And defendants, I'm sure it's a surprise to all of you who do civil litigation, that there are witnesses on the other side that don't remember things. And I think it's particularly bad whether you're representing a plaintiff to have key witnesses not remembering anything and just saying, I don't recall. So we lined up these people, and we, during the trial, showed how each of them were saying time and time again, I don't recall. Now, a founder of Genentech was Tom Perkins, Kleiner Perkins, and very talented guy, very, very wealthy. He had married this well-known romance novelist. He had, at one point, the most expensive, biggest sailing ship in the world, and he had it all computer controlled. He had umpteen different fast cars of various kinds. Each of those cars cost him more per one than the homes of anyone on this webinar. And we decided that we would have a young woman associate take his deposition because we had an assessment of how he might come across and how he might dislike being asked questions by a very young woman attorney. So I'll just play a little bit of a clip.
Do you remember what terms you thought were important to have in the 1976 agreement?
No,
Did you ever see any drafts of the 1976 agreement?
I don't recall.
Did you ever speak with Thomas Kiley about the negotiations of the 1976 agreement?
I don't recall, no. Not this specific.
Do you remember whether you gave final approval of the 1976 agreement before Genentech signed it?
I don't remember.
Do you remember discussing the 1976 agreement at any board meetings?
No.
So as you can see, he fit the mode of, in my opinion, being coached, not to remember anything. And his tone of voice, his slouching back, expressed, and this is just an individual's opinion, disdain for the questionnaire. So that's all part of trial practice. That's what makes trials fun for all of us. I would say the questioner now is a judge.
Excellent. Well, that's fantastic. Question from the audience, and I'll try to paraphrase here. They'd like to hear a little bit about your approach to objections during trial. Some schools of thought is if you're objecting vehemently to evidence, it really piques the juror's curiosity, versus you let it in and hope the jury doesn't catch it, but now, of course, it's in. How do you approach that situation?
I would say I changed my view over time. My natural instinct at the beginning, when I was a much more junior lawyer, was to object to everything because I could. It was, oh, he's crossing the line. That's terrible. I'll object. And then it became real clear very early on that a lot of objections were just totally meaningless. The questioner, even if the objection was good, would get around it. It's annoying. And so I try to object much, much less today. I try to pick out what I think is material. It's not objecting only if I think it's going to be sustained. During a period of time after I'd been practicing for, gosh, it had been probably at least 10 years, my instinct was still to object more rather than less. So I remember this was in federal court and it was a jury trial and there was a good witness on the stand and the judge leaned down and she started to ask the witness some questions. And then I said, I object. I stood and I said, I object, Your Honor. And she looked at me. I'm objecting to her question. And it dawned on me that my instincts were too strong. And she paused and said, Mr. Chu, overruled. And so I said, I thought you'd say that, Your Honor, with a smile, and I sat down. But the words I object came out of my mouth before I realized what I was doing. So generally, let the other side tell their story, attack their case on substantive grounds, on cross-examination and otherwise.
We just have another minute or so left. If we can bring it back to City of Hope, the jury, of course, not only awarded, I believe, over $300 million in compensatory damages, but ultimately it led to a punitive damages finding. Any sense, to the extent you can summarize it, what information you gave that compelled the jury to find so substantially in your client's favor?
Let me answer that by filling out a little bit more of the claims in the case and what I think ultimately helped us. It was a breach of contract case, but we also had a claim for breach of fiduciary duty. The law was unclear, and we thought that there was a good law that would allow us to argue that there was a fiduciary duty and that they breached that fiduciary duty. Of course, that would mean that we could tell the jury that they had the obligation, the responsibility to have full and fair disclosure at all times. And you can see how that plays into the facts of this case. Now, trial court and the California Court of Appeal upheld that breach of fiduciary duty claim. Ultimately, the California Supreme Court said there isn't a breach of fiduciary duty claim under the facts of this case, where you have a licensor and a licensee who are at arm's length. And so there was a $200 million punitive damage award. But by the time the California Supreme Court had affirmed the compensatory award for the past, $565 million was paid. It helped us. I say this by hindsight, but also at the time where we thought, we're not sure that we're going to be able to sustain the fiduciary duty claim all the way through all appeals, but it made admissible classes of evidence that might not have been admissible, which we thought helped us tell our story.
I love that. I love that. Okay, there are more questions, but unfortunately, we have to leave it there. Mr. Chu's time is precious, as is the audience's, of course, and we're at our 1 hour mark. On behalf of myself and the Beverly Hills Bar Association, Morgan Chu, thank you so much for the opportunity to speak with you and for all of us to hear some war stories and hopefully better our respective practices. To the audience, thank you for attending today. Stay tuned for further episodes of War Stories. There's going to be an October program, which will feature Mike Bedart of Chernoff Bedart, and a November program with my firm's own Adam Streisand. And lastly, as I mentioned at the top of the hour, your CLE certificates will be sent to you within 24 to 48 hours. Take care, everyone. Thank you.
Thank you. Bye-bye, everyone.